So you can write a good answer out of it. Contributory negligence, if I'm not wrong, is a short note in your paper, and it's a good answer to attempt. You might have read or you have studied this in your thoughts. So what is contributory negligence? When a person have literally given an answer here, you can jot it down. Contributory negligence is when both the parties are at fault. So say A accuses B of something and B says he is also at the same fault. So then the person who is accused or the person who is a victim is also involved in similar type of negligence, and that is why he is contributing to the incidents that has happened. Hence it is called as contributory negligence. Now if you see the definition, I've specifically mentioned that it is a defense in torts claims based on negligence. Let's say I am not at fault, even you are at fault. So if both are at fault, then who is supposed to be given compensation? That's one question that is important to be answered here. Contributory negligence occurs when the plaintiff's own negligence increases the likelihood of an accident or an injury. So basically, he is himself running a risk and taking the risk of doing something and being negligent at the same time. And hence, the person who has committed the crime, or say has the incident has happened, who's blamed for doing something for happening of the incidents, is not completely at fault. So I have given an example here where imagine a pedestrian who's crossing the street without looking both the ways gets hit by a car. Now in this case, the pedestrian's failure to exercise due care, reasonable care, without checking or without looking for cars around could be considered as contributory negligence. You might be reminded of Dunogwe versus Stevenson. That's a classic case of 1932 that talks about duty of care and which underpins contributory negligence. This is a landmark judgment. You might remember that the lady had gone in some restaurant and she ordered for ginger beer, and after or towards the end, she realized that there was a decomposed snail in it. She, of course, suffered gastroenteritis after consuming that. So the court held that the manufacturer, that is the defendant, neglected the duty of care. Of course, the person has to be aware, he has to take due care, and if it is not taken, because of which the plaintiff was injured, it is a contributory negligence. So to summarize it up, contributory negligence involves plaintiff's own failure to exercise due care and which may impact the ability to recover damages. Obviously, he is not going to get any damages out of it. It's essential for both the parties to consider their actions and responsibilities when assessing liability in such cases.